All right. Well, welcome back from lunch, everybody. I hope you got to go outside and breathe some fresh air. I'm over in Squim. It's a beautiful, beautiful day here. Hopefully, it's that same way across Washington. I gonna get ready for our next session here with Frank Acuña. But before we do that, just a couple things just wanted to cover. Number one, so we haven't drawn our attention to the leaderboard yet, but it seems like we got a lot of the same familiar people that are scoring high on the gamification of this conference. So right now we've got Beth Stone in first place with 355 points. Go Beth. We've got Tracy Raymond, 350 points in second place. We've got Marlene with 345 points. Marlene's always in there. She's always in the mix. And Andrea is 340 points, and we've got Claire with 340 points, and then Claudia and Drew and Zoe not far away. But just a reminder for those who haven't seen, so there's a scavenger hunt. So there's all sorts of items hidden throughout the event. You get points for that if you attend sessions, if you fill out the feedback form, if you register with the Guardian Community Forum. All of those things get you points, and then we're giving away, as I mentioned, iPad, headphones, registration to next year's conference, and some other things. And so make sure you're engaging there. And so what we'll do is I'm going to pass things off here to Frank, but first, let me give a little introduction. So Frank Acuña is a California State Bar certified specialist in estate planning, trust, and probate law. He's a founding partner of Acuña and Regli LLP with over 37 years of experience in estate planning, business and real estate succession, special needs trusts, and inheritance litigation. Acuña is nationally recognized for his expertise in real estate wealth transfers and advising professionals on financial and legal concerns. He frequently speaks at national conferences, teaches tax seminars, and legal ethics courses for fiduciary professionals. And it's with my pleasure to pass it over to Frank. Frank, you're in charge.
Thank you, Luke. I hear that 37 years and I go, dang, where did this time fly? But just remember, there may be snow on the roof, but there's still fire in the furnace. We're going to be okay. For all of you out there in Zoom land, please, 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 this is interactive. If you have questions, fire off a chat. And what's going to happen is Luke is going to be reviewing what's going on, and he'll break in and ask your questions at any time. I have no problem with that whatsoever. The other thing that I do want you to see is here on this screen, it's got the contact us at acuñaregli.com email address, or you can send me an email direct. My email address is ohc@acuñaregli.com. And believe it or not, the OHC stands for Outhouse Counsel. That's because you don't have an in-house attorney, you've got me. And you can ask me questions at any time. I'm happy to answer your questions about any of this stuff or anything else that comes up in fiduciary practice. Our firm is one of the most active firms in California, certainly in Northern California, when it comes to representing professional guardians, professional fiduciaries. Here in California, we call them fiduciaries. Our organization is the Professional Fiduciary Association of California. And when we talk about somebody who's conserved, talk about guardians, we talk about conservators. There may be a couple of things that come up where it might be state specific, but I'll try to highlight those. What we're talking about, though, are the general ethical concerns that all guardians, all fiduciaries have to be aware of. And let me see, where is that? Oh, doggone, where is that? There we go. Okay. It's funny. Ethics seems to have this idea that somehow it's convoluted and it's confusing. There really are three fundamental questions that all relate to one thing. Who am I? Tracy and I, my partner Tracy, we have said that we've never really met a dirty fiduciary, somebody who's out there and trying to take advantage of people. Indeed, people who become guardians, people who become professionals in this area, you've done this because you have a great heart for people and you want to help. And that's usually where we run into problems. And it's not that anybody's doing anything wrong, they're just doing more than they're legally supposed to do. So, answering that question, first and foremost, who am I? Am I the guardian of the person? Am I the guardian of the estate? Am I a trustee under a trust? Am I the executor or administrator under a will or an intestate estate? That is going to define a lot of your ethical concerns. So knowing who am I? Who is my client? Who is the person I'm supposed to be serving? And in what role? Once I know that, I'm not going to be exceeding my authority. Let me give you an example. And this happens all the time. We have somebody who is appointed as the guardian of the estate. They have all the power necessary to deal with the wards or the conservatees or the beneficiaries' financial matters. And all of a sudden, out of nowhere, the care home is calling you saying, we need to buy more meds, or we need authorization to move your client to whatever it is. And the wonderful helping guardian of the estate says, okay, let's move the client here, or let's change the treatment plan, or let's change whatever. Whoa. What you have there is you have the guardian of the estate now making decisions for the person in a situation where they don't have the authority to do that. It may be a family member who is operating under an advanced medical directive. And by exceeding my role as guardian of the estate, I've just created a heck of a liability trap. So that is what we're talking about here. Okay, once we know who we are, once we know who the client is, we have a duty of loyalty. And I'm using the NGA rules, the National Guardianship Association rules, because they're pretty universal. The guardian has a duty to avoid self-dealing and a duty to avoid conflicts of interest. Okay, if I know I am the guardian of the estate, or if I know I'm the trustee, then it's a really good idea that before I take the case, I review any documents or any court orders, and I find out whether or not I have a conflict of interest. There's a lot of ways that a conflict of interest can arise. The way that lawyers define this is that we will not take any kind of case in which we have a conflict of interest unless the client or the parties involved have waived the conflict of interest in writing. In your situation, especially if you are operating in a guardianship situation, a true court-ordered guardianship situation, you may need to get court approval before being able to continue when there's a conflict of interest. So what we've found in our practice is that these pesky conflicts of interest arise at the weirdest things. Let me give you an example. This would probably not be a professional, but it could be. The fiduciary is the trustee of a decedent's trust, and also is the trustee of a subtrust, where now what you have is you have the trust residuary beneficiaries and an income beneficiary at odds as to what should happen here. How does that come up? Well, gee, do you as the guardian invest for income, which will benefit the income beneficiary, or do you invest for principal growth, which will not make the income beneficiary happy, but will make the remainder beneficiaries very happy? There's that conflict of interest. Another example is, and this comes up all the time, you're trying to represent a ward, you're trying to represent a lifetime beneficiary, and their kids call, and they get you to answer their questions, and somehow they get the impression that they're important and that their wishes are controlling, where you know your client is that beneficiary, is that ward who is 100% entitled to your best efforts just that person. And the remainder beneficiaries, not so much. You can also have a conflict of interest when your attorney represents you and maybe another family member in another case. And one of the things you really have to do is ask your attorney, here are the names of all the players, the ward, the remainder beneficiaries, successor trustees. Have you represented any of those people before? And is that a conflict of interest for you, my attorney? And then, again, this last example where the attorney is now representing you as the guardian or proposed guardian, but had previously consulted, even consulting with another party can create a conflict of interest for your attorney. So these are all things to watch out for. Clearly, if you have a personal conflict, if you have a financial stake that's in conflict with your ward, that's a problem. Where does that come up? I actually had a case where the fiduciary, the guardian, owned a unit in a condo development, as did the ward, as did the conservatee. And there was a vote coming up that would have a financial impact on both the guardian and also on the ward's estate. So in that situation, that could create a conflict right there. Same thing with limited partnerships, some different investments or whatever. If there's a conflict, you are so much better getting out of that case and just declining the representation and decline it in writing. That's huge, because what you don't want to do is leave an impression with that ward or with that ward's family that somehow you still have a duty to act. Nope, you want to decline the representation in writing in plenty of time so that they're not going to be prejudiced by any kind of delay. All right, so that's the direct personal conflict. In every case, ask your attorney to review the estate planning documents or court orders and tell you who's the client, is there a spouse, what are the other beneficiaries or heirs at law. And this is something that I really want you to take away from today. When I first started representing professionals like you, there was this in California, they were not a licensed group yet. And there was this attitude that somehow they weren't real clients. You are an incredible source of work. You are an incredible source of revenue. Your attorney should be doing dances to get your business. And what we do at our firm, we actually offer a free consultation with our professionals to review a case before they take the case, before they take the court order, before they will go ahead and enter into a retainer agreement with the client or the family, just so that we can take a look at that. And this became super important in California because there was a California Supreme Court case where a trust was written and you had two groups of beneficiaries and they were doing this and they were also supposed to be the trustees, but the court said, oh, heck no, you guys cannot serve as trustees because you'll tear each other to pieces. And so the solution there was that in court, both sides agreed that they would hire a professional to act as the trustee. And the professional did so, I think it was for like 2 years, and acted as a trustee and did a really good job. And in this case, which was court supervised, the trustee offered their fee declaration in the petition for distribution so they could be paid. And what happened is that is when the court discovered, oh, there's a provision in this trust that says that the trustee will not be paid. See, because when mom and dad created this trust, they thought, of course our babies will do this and they shouldn't charge their brothers and sisters. But because of a poorly drafted fee provision in that trust, the professional didn't get paid. And the Supreme Court backed up the trial court and said, no, if that document prohibits payment, then even the professional doesn't get paid. So you want all these things checked by your attorney. You want to see what are the fee provisions, what are the or who are the players, What is the extent of your authority under this court order or under this document? All that stuff is stuff that your attorney should be doing before you take the case. Because once you've taken that case and the court has said, yes, that's it, you're done. You're stuck with whatever's going on. Okay. Conflicts of interest come up all the time. We touched on this briefly, but to talk about when you are serving competing trusts and you're going, what the heck are we talking about here? Oops, I'm sorry, I'm going to get back there. The most common competing trust situation there is married people. Often they will write an AB or an AC trust so that when one of the married people dies, the trust splits into two, a survivor's trust and a decedent's trust. So in that situation, you have income beneficiaries, the surviving spouse, and you have remainder beneficiaries of that decedent's trust. That's probably husband's kids from the first marriage. You can see where the conflict comes up. So again, sometimes it's better to say, I'll be the survivor trust beneficiary and get another fiduciary, another guardian to take the decedent trust. Luke, you've got a question out there.
Yes, sir. So Jason Hill says, is being appointed a guardian truly a lifetime appointment? It seems like it is.
Jason, it really does. It seems like it's a life sentence with no possibility of parole or time off for good behavior. If you are appointed by a court, you stay as the guardian until that court lets you go. Period. End of story. So you're going to have to petition the court for an order to relieve you as the guardian and have a new guardian appointed. If you are the trustee under a trust, the trust should have provisions in it that provide whether or not you can name a successor trustee and also under what conditions you can resign and how you have to do it. That's why it's so important to have your attorney review that before you take the case. Okay. So competing trusts, competing beneficiaries. Here's a practice pointer. And this is where a lot of new guardians really kind of fall down because they're not thinking quite enough ahead. Every guardian, every fiduciary should keep a database. And it doesn't have to be big and fancy. Outlook has an address book. Great. What you're putting in there is you should code them for who's a client, who's a beneficiary, what case did they come up in? And you create this database and it has clients and spouses and beneficiaries and all that other good stuff. That way, when you get a new case, you can search that database and see, did this name come up in another case? Do I have a conflict? Am I supposed to be representing a different party in a different capacity than I am in this one? And does that affect a former client or what have you? So good idea to name, to have a database. The database can also do something more for you. And that is, it is a great way to market. You know, when something comes up in the law or something comes up, maybe you write a blog article or something like that. Hey, that database is a wonderful database to send out the blog article to. And they'll talk to their families and they'll talk to their friends about what a wonderful fiduciary, what a wonderful guardian you are. All right. So best practices with conflicts of interest. Have your attorney review the doggone thing. When the review is received, input the name of the prospective client, their relatives, the date of the consult, any attorneys, get that into your database. And then at the same time, search that database for the prospective client and their relatives. See if they come up in other contexts. See if you do have the potential where you're maybe representing somebody in this case that may be adverse to that case. And if there is a conflict that's found, have your attorney review it. Have your attorney advise you as to whether you should take the case. And you may want your attorney to draft the letter to everybody to inform them of the conflict, or in a court-appointed situation, to inform the court. Ask your attorney to check their files. Do they have cases where somebody who could be adverse in your case was somebody they represented in another case? And if there's a conflict that exists, if there's a conflict with the attorney, a good attorney will understand if you say, hey, I would really like to work with you, but not on this case. The next one that comes in, I'll give you a call, but we've got a conflict here. And again, for you, because you don't have the same liberal standards as to conflicts of interest that attorneys do, if there's a conflict that exists, if you're going to decline the representation, do it in writing and make a note in your file and in your database. All right. There's another kind of conflict. Again, we've talked about this, and that is that the attorney can create a conflict of interest. It's not you personally, but it's your attorney. So again, watch out for that. Make that attorney check their database, and if there is the potential for a conflict of interest, have that heart-to-heart talk. All right, here's a case study. Lily and Stephen meet with Anna attorney to appoint a conservator for their son who has, or a guardian for their son who has a traumatic brain injury. They're elderly, don't believe they can do it. Anna calls Connie conservator. Connie agrees to take the case and to hire Anna to represent her. After Connie's appointment, Lily and Stephen filed complaints against the care home chosen by Connie and expressed concern about how much is this costing our son. Okay, this is the typical conflict that comes up. And in this situation, if Anna attorney had represented Lily and Stephen, and in this case did, and also wanted to represent them in the complaints against Connie conservator, and Anna attorney was also Connie conservator's attorney, you can see where the conflict of interest is there. So you definitely don't want to waive that conflict. You don't want your own attorney helping somebody else to sue you. All right. That's pretty much conflicts of interest in a nutshell. And it really, really, really is resolved in many ways. If you know who you are, if you've done your own conflict check, and if your attorney has done a file review and done a conflict check on their file as well. Those are the three big things that would change or that make it so much easier if you do those three things. I'm going to take a brief pause. Anybody out there who's got a question that you'd like to shoot out there in the chat about conflicts of interest or a war story that you'd like to share? Okay, let's talk about the duty to act competently. And I'm really speaking more to the newer professionals out there. This is the PFAC, Professional Fiduciary Association of California Code of Ethics, and they say that a fiduciary shall, a guardian shall comply with all statutory requirements, be knowledgeable of applicable policies and procedures, keep informed of existing local, state, and federal laws as a minimum guide, and never exceed the bounds of their legally granted authority. That's not too hard a standard to meet, but where we get the duty to act competently coming into ethical problems, coming into lawsuits and claims back and forth against guardians and people out there is, do you have experience with this kind of case? If you are somebody who comes out of the financial world, do you have experience with care plans and managing care? If you're somebody who comes out of the care world, do you have sufficient experience to deal with investments, real property investments, limited partnerships, and all that other good stuff? So that's where we see the duty to act competently coming up, is now you're, or possibly even a different type of trust. Have you ever administered a special needs trust or a charitable remainder trust or a life insurance trust before? That doesn't mean you have to turn down everything that's new. Okay, so let's take a look at this problem here. Fiduciary accepts appointment as trustee of a special needs trust, but never reviews the trust. Fiduciary serves as a trustee for many special needs trusts and knows how to administer them. After a few years of administrating the trust, she realizes it requires court-filed accountings and has a very restrictive distribution provision. Okay, how does she get out of this problem of acting competently? Well, first of all, that idea of taking that free review of the case before they took it. Second, creating a checklist for the cases and helping to spot unusual or problematic provisions. And third, listening to your gut. Oh my goodness, if something inside of you is saying, don't take this case, don't take it, or get somebody else's advice. This is the situation of a experienced fiduciary. But this really kind of shows the trap for experienced fiduciaries and also inexperienced fiduciaries doing what seems right. What seems right is often not what's authorized in the court orders or in the document. So what you have is in all jurisdictions that I've seen, and I'm pretty sure in Washington you have it also, that you can go to court. Either you have a notice procedure where you can tell everybody what you're going to do before you do it and let them object or not, or in all jurisdictions, you have a procedure to simply go to court. This is on a will, a trust, a guardianship, whatever, and ask the court to instruct you. So if you're not sure, if there seems to be competing claims as to whether or not the house should be sold or anything else, you can go to court and say, I am intending, dear court, please tell me if it's okay for me to list the house at X number of dollars or what have you. Great, great. Because once the court says you can do this, you're safe. Because to do that kind of court proceeding, you're going to give notice to all the affected persons. They're all going to have a chance to scream, cry, jump up and down, and turn purple. And once the court tells you this is okay, then you can do it safely. So my solutions in these things is, instead of just flying and doing what seems right, talking to your attorney, giving notice if your particular case allows you just to give notice and an opportunity to object among all of the interested parties, or going to court and asking the court to instruct. You're a new guardian, and you really don't have a lot of experience with finances, or you're a very, very seasoned guardian and you've got a case that has a financial aspect. Acting competently can either be you have the expertise to do it yourself, or you seek competent, qualified advisors, and you can delegate some of these things as long as you are exercising independent oversight and control. This is huge. This is huge. Even if you have financial expertise, if you are not a certified financial planner or something along those lines, we advise all of our fiduciaries to hire a financial advisor, a fiduciary financial advisor. This is important. They'd also be fiduciaries. They're people who are not making money by selling investments. They are advising, they get paid for their advice, and their advice is the way it's paid for is simply that they get paid by how well the portfolio performs. What we want on the financial side is a financial plan, something in writing that says, this is our investment plan, this is our spending plan, this is how we balance the two. And because of that, your financial advisor advises you as to what is a good investment mix, what are good horizons there. And that investment plan, the spending plan, should be revisited annually and amended, adapted, rewritten as necessary. Beyond the annual investment plan, we advise that our fiduciaries sit down with the investment advisor no less than quarterly, and often more if something crazy is happening in the markets. And as you all know, if you've watched in the last 90 days, things are crazy in the markets right now. Great time to sit down with your investment advisor and get that investment advisor's advice in writing as to what you should be doing. What you don't want to be is in a situation where you are managing the investments and without advice and without looking at your investment plan, you're making snap moves. Okay, it's not just on the investment side. Again, we advise our guardians, our fiduciaries, to have an investment plan. And if they are in charge of the person, we want them to have a written care plan. What is the appropriate level of care for this particular client? What are they going to need? Is it in-home care? Is it supplemental care? Is it assisted living? Is it memory care? What? But go ahead and in writing, you have a care plan of how that person is going to be cared for and what the next stages are and how that will be evaluated. And again, that's an annual document, investment plan, care plan, and reviewed at least quarterly with your care advisor. In California, we are fortunate. The courts here are recognizing that fiduciaries, guardians do need investment advisors and care advisors. It really comes to a head in special needs trusts, because in a special needs trust, these are typically long-term trusts of people who have abilities all throughout the spectrum, from people who are totally bedridden and it's a matter of just managing their medical care because there is nothing more that they're physically or intellectually capable of, all the way to these the particular client in this case enjoys bowling, wants to go shopping, has all those abilities, but needs help with that. In that situation, again, your investment plan is the long-term trust, making sure that the investments last as long as feasible while still taking care of all of the client's needs. That's huge. Having a care plan so that you know what the budget is. And then sometimes, especially in special needs situations, having an advisory council. Now, this is often, it should be in the special needs trust that you are able to put together a group of advisors. And what this advisory council could do for you is you're the professional guardian, but you don't have the history with a special needs consumer. You don't know what they enjoy, what they're capable of, what has been their pattern in practice before you came on the scene, before mom and dad passed away. And now you're helping that adult child in a special needs trust situation. In that situation, being able to put together a council, and that council could include financial advisors, care advisors, and family members or friends who knew and who know the consumer and know what enriches their lives. That is an awesome, awesome, awesome way to enhance the services you're providing to a special needs consumer. In California, I'm going to really highlight this. Medi-Cal in California is radically different than Medicaid in other states. California is much more liberal in what they will allow to have happen. In California, again, subject to the limits that a special needs consumer can have, debit cards and gift cards are a possibility. In other jurisdictions, they are not. Please check with your Washington counsel on this. So that's kind of, an idea there, but definitely getting competent, qualified financial, care, and advisory people, huge to helping you act competently. Oh my gosh, this is an actual one that I handled. And you think, okay, financial professional, care professional, advisors, get ready for this one. Guardian is hired, is on the job, and needs to sell property that was in the estate. This is the guardian of the estate. And so what they do is they hire a handyman, and they went out and did repairs to the house, got it ready for sale, and the house sold. And then the estate was sued because allegedly the repairs were not up to snuff. Not only was the estate liable in that situation, but the insurance for the house and the insurance for the guardian both denied coverage. Because in the guardian's, in certainly the house said, hey, this is a modification, but the guardian's errors and omissions, their malpractice coverage said, oh, no, 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 no. See this clause here? You had to use a licensed contractor, and when you didn't, we're entitled to void coverage. Ouch. So it goes beyond just reviewing that particular case, but also it's a good idea every year to have your malpractice coverage reviewed as well. I saw chats coming up. Jason, do we have anybody out there?
We do. We have Brenda. So Brenda says, I have a client with a 30-year annuity that developed from a car accident. It funds a S&T. As it is not income generating, do I still need to have someone review it?
Yeah, an annuity is a little bit different. If the annuity has an element of you have the opportunity to pick the investments or to arrive at the investment plan, then you should have it reviewed. If the annuity is strictly, some annuities are just the insurance company says, you're going to get this payment each and every month or each and every quarter or each and every year, and it's up to us to make all the investment decisions, then no. What you might want to do is you might want to have that annuity reviewed simply because it's a 30-year annuity. Look at the consumer and say, hey, does that annuity still fit? If the annuity has only, if the consumer has only a 10-year life expectancy and you've got a 30-year annuity, you may want to go ahead and restructure that annuity to provide more for that person's needs. Or you may want to again look at maybe I remember when cystic fibrosis was almost a death sentence for teenagers. And now I have clients who are in their 60s with a CF diagnosis and doing fine. The annuity that may have been fine with the first life expectancy may need to be restructured or may need to be protected at all costs because it's still paying years and years and years later. I handled an annuity case where the annuity was structured to keep going up by a specified amount each and every year, because when it was first purchased after an auto accident, the consumer really had a very short lifespan. Now with all the automatic increases in that annuity, it is paying close to $1 million a year, and that need is not there. So in that situation, again, as the attorney, I wanted the annuity reviewed. I wanted to make sure that there were no ways to cancel that annuity because, oh my gosh, that one was the golden annuity, and we wanted to make sure that we were protecting it. I saw another chat out there.
Yeah, so Leah had made a comment, if property is mentioned or address is provided, we do a search on that as well to see what we may be getting into.
Absolutely. And I did, Tracy and I worked with an insurance professional, a financial professional, a tax professional, and we did a pre-conference intensive. It was an all-day pre-conference intensive called 30-60-90, the checklist that every fiduciary needs to know. That first 30 days or before you even take the case, it's not only check those addresses for the real property, it's also check the insurance and make sure there's good property insurance, homeowners insurance or what have you on that property. Because again, we handled a case where the fiduciary got involved in the case and was getting his arms around it. And in the first 90 days of the case, the house burnt down. And it turned out that the homeowner's insurance had lapsed on it. And now that fiduciary is looking at a case where they are 100% liable for the loss of that house. So it's not just check the real estate and whether there's a toxics problem or a bad neighborhood or what have you. It's also check the homeowner's insurance on it. Anything else, Luke?
That's what we've got right now.
Okay. Oh, tax returns. Oh my goodness. I cannot tell you how many cases I've become involved in where the fiduciary, the guardian takes over, the guardian of the estate takes over, and we find out that there was no tax return filed for years. I just answered an email from a tax professional, and the question was, mom died in 2016 and they haven't filed any 1041s. How far back should I go? And the answer is all the way back to 2016. Make sure you have a really good tax professional who really understands Form 1041, the fiduciary tax return, and get those doggone things filed timely. If you have a new clients, maybe they died, maybe they're still alive, make sure that their Form 1040s have been, their personal tax returns have been filed timely. And if they haven't, fix them. This next one is to really to new or less experienced guardians. And I'm taking this from the rule of professional conduct for attorneys. This comes, we're very much alike, attorneys and guardians. And in that our standards for malpractice are very, very similar, competent representation. When I was a baby lawyer, just out there freshly minted with my new bar card, I didn't know anything. So truly, if I had to be competent in whatever case I took, I couldn't take anything. But the standards are a little bit more generous than that. If I can gain that expertise, or if I can associate in with somebody who has that expertise, then I'm okay. And so if I do certain things just to make sure that I don't get overwhelmed and that I am competent, it's going to take care of a lot of stuff. Number one, be honest about your case list. If you've got too many cases that you can't manage them all, and for a new guardian, that's going to be fewer cases, then don't take any more cases until you've cleared your decks. And if you don't have the particular expertise needed for the case, then go ahead and associate in, share the case with a more competent, with a more experienced guardian. It's a great way to get to know those guardians. You experienced guardians working with your younger counterparts. This is a great way to start building up your succession plan, so that when the time comes to retire, you've got something to work with. So again, making sure you can take on the case from a competence view, from a caseload view, from the pressure from a client or referral source. Often there are substance or emotional issues out there that you have to watch out for. And then with our law firm, every time we've grown, what we've done is we've stopped the growth, worked on our infrastructure to make sure that we could handle things competently, and then started to take the cases. Okay, I saw some chats popping up.
Yeah, so we've got Dan saying, is there an income threshold that needs to be met which dictates whether you have to file a 1041 for your client?
Yep, $600 a year. If you have income in excess of $600, and in some cases it's less than that, but again, the $600 threshold for federal returns, I think, is a pretty good threshold. Please, please, please check with your enrolled agent, your CPA, or your accountant to make sure of that, and also make sure that there are no different threshold requirements in Washington.
We had Jamie make a statement. We just became a successor trustee for an S&T benefiting a minor. The review of the trust indicates it was set up as a grantor trust, so the minor is paying the taxes. That won't work, as the minor child is disabled and will need services as an adult. We now have to reform the trust in the next year, or DSHS will not qualify her for benefits she'll desperately need. Please review your trusts and court orders.
Thank you for chiming in on that one. And it really does show how important that initial review is. You could go into court and fix problems with a trust, and it's much easier doing it at the beginning, either before you take the case or just as you've taken the case, than it is to find out 2 years later, 3 years later, 6 years later, that something really bad was going on in that trust that's going to bite you. Any others?
Oh, we just had one come in from Laura.
Yeah.
Client passes as one of three beneficiaries. Investments have been divided and distributed to two living siblings. So, does the deceased client's funds remaining go to S&T or survivors, or, oh, whoops, or to Washington State, who paid cost of care for over 30 years?
Yeah, that that's a typical situation. I don't think that there's a question there. It really would, that one would be something that I'd like to see the trust, and I'd like to see who the remainder beneficiaries are and what reporting is necessary. Is there money owed to the decedent's estate because they were supposed to get more income than they actually got? There, or more income expended for their benefit. Again, without looking at the trust, there's not a whole lot that I can comment there. All right,
Okay. Oh,
go
and then
ahead.
last thing, Jamie shared DSHS can consider reformation as a transfer with a 5-year look back.
Love it. Love it. So you've got a 5-year standard, and then you've got a look back provision. Other states are different. Others won't look back at all. Others will, but for different time periods. Great. I really appreciate that Washington's got a 5-year statute. That's a nice long look back. Okay. We've talked about conflicts of interest. We've talked about duties to act professionally. I'm going to let you in on the number one thing that gets every professional sued. I don't care if you're a guardian, a doctor, a dentist, a lawyer, a tax professional, a financial professional. The number one reason any of them are sued is problems with communication. Either, as they said in Cool Hand Luke, the failure to communicate, or bedside manner just isn't good, or the communication just isn't up to snuff. And this can be really, really simply remedied by establishing a timeline and calendaring your important dates, including dates that you're going to write a report, not just to the court, but perhaps to the remainder beneficiaries or whoever's entitled to the information. Now, make sure you're advised as to who's entitled to the information and that you're not giving away private information that belongs to this person, excuse me, to people who aren't entitled to it. But, for example, guardian takes on a new trust case, they're going to be the trustee. And this is a simple case where you're going to just wrap up the trust and distribute the proceeds. But this family has been at each other's throats and what have you. One of the most important things I've seen done, and this is a great, great, great fiduciary who did this. She writes what is called an INA letter, which is basically, dear beneficiaries. She's already given them the notice that they got that she's the trustee, and they've also gotten a copy of the trust if they're entitled to it. But then she also writes a letter that says, I'm new to this case. We are gathering the assets, and here is the inventory of what assets we have, and also the inventory of what claims we might have, creditors out there. If you have any further information, please let me know. Wow. Early on, those beneficiaries are getting communication, and they know that they're being kept in. Now, she's also very, very, very careful as to who gets those communications. One thing that I teach, that Tracy teaches, that she now, same fiduciary, has taken on. There is no way on God's good green earth that I would ever give my phone number, my personal phone number, out so that people can text me, for a couple of reasons. Yes, I have a duty to communicate, just like you do. But do I honestly want to be available 24/7, 365 to every family member that's out there? Second of all, there are now good apps out there where you can print out texts, but it's another, if you are allowing your texts to be used, your phone to be used for texts or what have you, then that is, if you're ever in litigation, that's another place that people are going to be able to go and get all the data off your phone. So what I do, and what I urge my guardians to do, is to invest in an app on their phone. The one that I use is called GoTo Communicate. And what that lets me do is on my personal phone, I can have, it's an app that has my business phone number on it, so that when I call out, you see my business phone number, not my personal phone number. And it's someplace where I can check my voicemails at the office on my business phone number. I never ever, and I earlier urged my fiduciaries, never ever give your personal phone number for texts or for personal phone calls. Business is business, personal is personal. When I communicate with clients and family members and opposing family members, and when you are communicating with all those wonderful people, I love emails. Emails are great because with email, and I urge you, if you have a case where you have multiple beneficiaries and there's one pill who's bugging you and asking you questions every time you turn around, put your policy out there that if I communicate with one beneficiary, I owe duties to all of you. So all the beneficiaries are going to see the email and the reply. What does that do? Number one, it tells everybody, gosh, my brother's being a pill and he's costing us money. Number two, you've dealt with the duty to communicate fairly and equally with all beneficiaries. So they're all seeing what the question was coming in. They're all seeing what the answer is going out. And because you have an email, you have a very, very simple and complete way of saying exactly what questions came in and what the answers were going out or what your report was going out. I'll be really, really honest with you. One of the things I tell my clients is that I am the worst telephone attorney on earth. And I'm a bad telephone attorney because I'm always in meetings with my clients. So playing telephone tag to answer telephone calls isn't going to happen. So what I did as an attorney is I told all my clients, I will never charge you or your family for emails. What I just did by doing that is I've now shifted them. They know that they won't get a bill if they send me the email. Now I have a record of every question that came in and every answer that went out. So if I'm ever sued for malpractice for giving bad advice, oh, no, no, no. My advice is right there in writing. The other thing I've done, this morning I handled 40 emails. If I had to return 40 phone calls, I'd be here until next doomsday. I'd never get something done that I could get paid for. But because they're in emails, I can scan them, I can answer them, and I'm done in an hour. And my clients think, wow, that attorney got right back to me the very next business morning, and I've got my answers. He must be a really good attorney. Same thing for you as a guardian. If you establish a way where you can manage that flow, where you can compartmentalize that flow and get your work done for the people that are important, for your clients who need your services, consider it. I'm not saying it's the right situation, it's the right solution for everybody, but for me, going to emails and really managing my emails and who gets them has been huge for enhancing my reputation as an attorney who communicates. Oh, by the way, watch out for your CCs and your replies and your reply alls, because sometimes there are people on that chain that you don't want to receive the response, or replying when you should be forwarding to your assistant. Ooh, ouch. So, okay. Case study here. At the end of trust administration, each of the 4 beneficiaries had become upset, believing that John kept and told secrets, and that he sided with the other beneficiaries and misinformed them of their rights and what he was supposed to be doing to help them. What should John have done differently? Here, if you have 4 beneficiaries and you are the guardian, you're the trustee of this trust, communicating with all of them so that they all see the questions and they all see the answers. Perfect way of proving that you communicated promptly and fairly with all of them. All right. Confidentiality is the flip side of communication. There are sometimes that you need to say things in confidence. One of them, of course, is when you're communicating with your attorney. Gosh, help you. And I said, gosh, help you. If you let your communication with your attorney be known to everybody. Luke, you got your hand up.
Yeah, one person put in the Q&A area, they want to know if a POA should be paid for their services. I've heard some people say that a POA does not make any money, and that's usually from someone who is not a guardian. I've heard guardians state they charge fees depending on the case. I would like to know what guardians charge for being a POA, and how do they determine their rates? Is this legal as a POA?
Okay. I'm not the right person to ask about charging and what rates you charge or whatever. I will tell you that in my mind, the POA and the trust are two pockets on your in your client's financial paths. There are some things that go in the trust pocket, and you're the trustee of, such as the house or accounts. Some things don't go in the trust because it causes bad things to happen. Retirement accounts do not go into the trust in most situations because the IRS considers that a taxable distribution. So if you have an incapacitated client, you need both. And signing tax returns is often not in the trust, it's in the POA. So yes, in my mind, you should be charging for all of your services if you're in charge of the estate of your client, whether it's on the trust side or it's on the POA side. And in my world, when I draft things for my estate planning clients, I make sure that there are fee provisions in both.
And Jamie made a comment to that. She said, we charge our regular fee. It's legal and it's part of the agreement with the person who is asking us to serve. It's basically a
Absolutely. Absolutely. And so again, in a good estate plan where a trust is involved, I want to see both the trust and I want to see the POA to cover incapacity. I want to see the trust and I want to see a will in case of death, just in case there's an asset that needs to be scooped up and placed into the trust. You need a pour over will. So, okay. And I'm seeing another comment from Claudia saying, yep, I charge and I charge the same doggone fee. Absolutely. So I'm going to just kind of go in here. There's another duty that's starting to come up in the litigation about protecting the clients from a foreseeable risk, such as losing public assistance benefits. So again, the idea of acting competently and bringing in other professionals when necessary, making sure that you are bonded in the appropriate cases and bondable, and always, always, always carrying errors and omissions insurance, malpractice insurance. I wouldn't come to work without malpractice insurance. So I'm going to zip on ahead. There's fee agreements and endgame ethics. But one thing I want you to know, our practice is largely built on professional guardians, professional fiduciaries, and we are happy to answer questions. If you have local attorneys in Washington, please, you've got to have your own attorney. But if your attorney would like to just kick ideas around, give them my contact information. Again, this is contact us at acuñaregli.com. Mine is OHC, Outhouse Counsel, OHC at acuñaregli.com. I'm going to kick this back to Luke. Do you have closing remarks, or do you have closing comments or questions we should talk about?
No, that's it. Lots of feedback just at the end. People saying, great job. One person saying, it's my understanding that professional liability insurance may require a proof of fees or at the least a no charge of designation for services provided but not billed. And yep, lots of thank yous. You're amazing, Frank, and all that. So no,
All right.
I added that.
Please, we are a resource. Please use us. Please ask the questions whenever they come up. And thank you so much for the invitation to talk here tonight or today.
Hey, really appreciate that, Frank. And we've got some, I believe, access to his PowerPoint here for those of you who want to look back over that in the platform. But at this point, we're going to take a 15-minute break. We'll be back here in about 15 minutes with Peter Wall talking Secure Act 2.0. And
I want
so
to see that one.
you can join.
Okay.
I'll give you access if you want. So all right, thanks Frank, thanks everybody.